She bought a house, $900,000, cash. She bought it for her children, close enough that they could walk to her. She was legally barred from ever setting foot inside it. A mother, a lawyer, someone who spent her life inside the system. The same system told her she could never see her children there. 3 weeks later, she was dead. This is not a story about a villain, and it is not a story about a hero. This is what the system looks like when it works exactly as designed, and still destroys everything. The question is not what happened. The question is, when does the process itself become the problem? If you are new here, this channel covers real cases of betrayal inside American institutions, not for the drama of it, for the understanding. We document what the record shows. If you are watching this because you are currently inside a custody proceeding, or you have been, this was built for you. Not for the people who want something to watch. For the people who already know what it costs to sit across a table from your own life, surrounded by professionals who get paid whether you make it through or not. A few weeks ago on this channel, we covered a case where one party buried over $1 million in marital assets and walked away with a favorable settlement anyway. How information gets hidden, how process gets turned into a weapon. The mechanics there are the same mechanics operating here, just louder. This case did not stay buried. It became one of the most viral family court stories in recent American memory. To understand what happened here, you need to understand who these two people were before any of it started. The husband was a patent litigator, a shareholder at one of the largest law firms in the United States. His documented annual income, between $800,000 and $1 million a year. The wife was special counsel for a sub-cabinet ethics committee in the New York governor's office. Her documented annual income, $170,000 a year. Both were attorneys. Both knew professionally exactly how courts work. That matters. In a custody proceeding, the party who can sustain litigation longer holds structural advantage. That is not commentary. That is how the billing works. May 2019, the husband filed for divorce in Westchester County Supreme Court. 3 daughters. By the time this case ended, they were 9, 12, and 13 years old. What followed over the next 4 years was not structurally unusual. Family courts see versions of this constantly. What was unusual was the duration, the cost, and where it ended. The court appointed 4 judges across the life of the proceeding, 2 forensic custody evaluators, 4 separate attorneys for the children, multiple court-appointed therapists. By the time it ended, the husband stated publicly that court-ordered settlements paid to the wife totaled $885,000 over 3 years. The wife, in her final public statement, said the husband had spent over $3 million on litigation. Neither figure was independently verified by a third party. Both are in the documented record because both parties put them there. There is a term that practitioners in high-conflict litigation use when things reach a certain point. They do not say it in court. They say it to each other afterward. Scorched earth. It means one or both parties have stopped trying to reach an outcome. The goal has become exhaustion. Outlast the other person. Make the cost of continuing higher than the cost of giving up. Between 2019 and early 2023, the case moved through its standard procedural architecture. Hearings, evaluations, temporary orders. Here is something family court practitioners know that most people outside the system do not. Temporary orders calcify. What starts as a provisional arrangement meant to stabilize things while the case resolves can become the de facto permanent arrangement through sheer duration. The longer a temporary arrangement holds, the more disruption the court perceives in changing it. Legal professionals call this status quo bias. What that means in practice, if a temporary order reduces one parent's access to their children, and that order sits in place for a year while litigation grinds on, the reduced access has become the baseline, not officially, not permanently, but functionally. And in family court, functionally is most of what matters. As the proceeding progressed, the wife was placed under a series of constraints. The record shows supervised visitation was ordered at points during the case. April 2023, she purchased a $900,000 home in cash near the marital residence. Sit with that for a moment. She was an active party in a custody proceeding. She was under court orders restricting her access to her children. And she spent $900,000 on a house specifically to have a home ready for them. That is not what someone does when they have accepted what is happening to them. That is what someone does when they still believe, in April 2023, after 4 years, that the outcome can change. May 2023. The second forensic custody evaluator submitted the final report, the recommendation: sole legal and physical custody to the husband, 0 contact for the wife, no supervised visits, nothing. The presiding judge, the fourth judge assigned to this case, immediately ordered all contact between the wife and her 3 daughters stopped. She had not been convicted of a crime. No court had found documented evidence of the specific conduct she had described in her own filings. The report landed in May. The order was immediate. The house she had purchased in April, the one she could never step inside, so I was 3 weeks away from her daughters. May 27th, 2023. She published a post on Facebook. It was not an ambiguous post. She stated she was ending her life that day by medically assisted death in Switzerland under that country's assisted dying laws. The post contained a Dropbox link. Inside that link, thousands of pages of court filings, legal documents, medical records, and recordings she had archived over the course of the proceeding. In the post, she wrote, "The court system did this to me. It is a predatory system that functions in darkness, through gag orders like the one in my case, through a publicly inaccessible docket, through a closed courtroom, and through ex parte temporary orders that are in place for years." She also stated she had been diagnosed with terminal cancer. The husband disputed that claim in subsequent court filings. No independent medical verification was ever made public. The record on that point remains unresolved. She was, by documented record, an attorney. She understood exactly what she was. She understood exactly what she was releasing and what it meant legally. The archive was not an accident. It was a deliberate act. She died in Switzerland on May 27, 2023. Her daughters were 9, 12, and 13 years old. The Dropbox archive went public. Within days, a TikTok creator began publishing a series of videos drawing on the archive documents. 23 videos, millions of views. The husband's law firm, one of the largest in the United States, announced his immediate resignation, not after an internal investigation, not after a court finding, after social media pressure. That sequence matters, and it cuts in more than one direction. On one side, a body of archived documents released by a woman who had spent 4 years trying to get the institutional record taken seriously, achieved in 72 hours what 4 years of proceedings had not produced. On the other side, the husband has maintained consistently that the proceedings were conducted properly, that 4 judges and 2 independent evaluators reviewed the evidence over 4 years and reached their conclusions through the established process. His position is that what happened online was not accountability, it was a mob. Here's what the public record can and cannot tell us about what came after. The 3 daughters are still alive. They are minors. Their current circumstances are not part of the public record, and we will not reach beyond what the record shows. The custody arrangements in place at the time of their mother's death, we do not know their current status. The house she purchased in April 2023, but we do not know what happened to it. What the record does show, no judge in this case faced a formal disciplinary proceeding as a result of the public attention. No forensic evaluator faced documented professional consequences. The institutional structure that produced the outcome remained intact. Millions of views, a corporate resignation, a defamation lawsuit, a sealed settlement, and no documented systemic change anywhere in the record. That is the title of this video, the case that changed nothing. Not because the people in it didn't matter, because the system was never designed to change based on what happens to one person. 4 out of 5 custodial parents in the United States are mothers. That is not an advocacy claim. That is United States Census Bureau data from 2018. Only 4% of custody cases go to trial. 4%. That is also Census Bureau data. The other 96% are resolved or exhausted before a courtroom ever decides anything. That means outcomes in the vast majority of cases are shaped by what happens in the process itself, the filings, the evaluations, the orders, the attrition. 66 million cases move through state courts every single year. According to Clio's 2026 analysis of court system data, 3.8 million of those are family law cases. 3.8 million. That is not an abstraction. That is 3.8 million families standing somewhere inside what this case documented. The court received the report. The court acted on the report. One professional, one report, one procedural cycle, all contact ended. That is not an anomaly in this system. That is the system functioning as built. This case becomes a fixed reference point for this channel, not because every case ends this way, because the structure that produced this outcome exists in smaller form in cases that end quietly, cases that never go viral, cases that nobody archives. There is one more thing. If you have been through something like this, or you are inside it right now, there is a reason this channel exists, not just to document what happens, but to collect it. Patterns only become visible when enough people are willing to put their experience on record. There is a submission form linked below this video. You do not have to share everything. You do not have to share your name. But if you choose to, what you submit becomes part of a larger record, one that does not disappear when a case ends. A system can operate exactly as designed and still destroy someone. The three daughters are somewhere right now. They are not public figures. They did not choose any of this. We will not speculate about their lives. What we can say is that the case their parents built across 4 years, 4 judges, 2 evaluators, and millions of dollars now lives in a public archive that their mother put there deliberately. She made sure someone would know. Whether knowing changes anything, that is a question the documented record cannot answer. The next case on this channel starts with a number, $42,000. That is what one party claimed they earned each year. The documented figure, found 3 years into the proceeding, was closer to 6 times that. How that concealment held inside a system specifically designed to surface exactly this kind of information, that is what the next video is about. If you have ever wondered how someone hides what they actually earn in plain sight inside a legal proceeding, that video answers it. It is on your screen right now. Share so they don't miss what comes after that. And if this video reached you because you are in the middle of something you cannot fully explain to the people around you, you are not alone in what you are seeing. The record shows it happens. More than anyone admits,